Okay, and the second appeal that the city received on July 31st was from the successful appellant at the original Board of Adjustments decision that this council decided and remanded back upon. Like I explained earlier, that decision narrowed the issue for the Board of Adjustment to decide, and they did that and they made their decision. This appellant believes that the decision that was made by the Board of Adjustment on July 18th was not supported by substantial evidence. And I explained in there and provided some case law and some black letter law on what is substantial evidence. The appellant also says that the decision that was made on July 18th was arbitrary and capricious. Also in your material, there's information on what is arbitrary and capricious. And then the third argument, or the third issue that was raised, the appellant said that the decision of July 18 deviated from Moscow City Code and protocols for the appeals hearing. And in there, I don't know if it was a strong argument. She wasn't sure exactly what it deviated from, but there were some discrepancies in the process she wanted to raise. As part of the judicial process, quasi-judicial process, and when you're doing a review, you look at the totality of the circumstances. You determine, make sure that people got their proper due process, they were properly noticed, had a proper opportunity to be heard, and then the board deliberated and made their decision based upon the law that they were required to, and the relevant criteria and standards, and then that they put that decision in writing. And that process has been followed. We have followed our city code to the very end of that chapter on appeals, and the issue before you is of whether the council thinks that there's anything in here to any validity or any merit to grant any of these parties extrajudicial process or extra due process. And there's two issues what I would recommend that the council deals with. The first appeal from the Von Linderen and Von Braun concerning the notice and the procedural error. And then I would also recommend that you make a decision on the second appeal from the successful appellant of the earlier decision.
Okay.
Walter, you have something to say?
No, I'm good at the moment.
Okay, we've got two decisions to make here before us on the two appellants, and the one we're going to speak about first is the Von Linderen, I hope I pronounced that line right, and Von Braun. How would council like to move forward with that?
Well, can I just say that I think you have a couple choices. You'd either deny the appeals, or if you're going to grant the appeal, you would have to set this for another hearing to be properly noticed.
Art?
Well, I'll jump on first, and the two comments they have about not receiving notice of public hearings. If you own a property with a mailbox, you should be checking it. And the fact that the letter was not sent to a residential address as opposed to the business address that was within the 600 feet of the property in question does not relieve the owners of that property from their own due diligence in paying attention to what's going on. So on the case of not receiving any notice, written or otherwise, I don't see that happening. And on their second one about the procedural error, the city code says 10 days, and the 10-day line, as I understand the timeline, extended from the time in which the Board of Adjustment submitted their final reason statements, correct?
Correct.
So
Originally.
yeah, the original statement.
May 1st.
So with the provision of the written documents and then 10 days from there, I think that includes any of the time within the state's stipulation of 14 days that would include time to prepare the written documents. So I think that in keeping with the city's ordinances, the city's on solid ground with that one too. And so, for my opinion, I don't see enough grounds to move forward with support of this appeal, just for those legal issues.
No, I'm going to have to agree with Art that I can't see where this has legal standing because of, if they received proper notice according to the rules and did not appeal originally, then they don't have standing to appeal the remand decision, and therefore we should probably reject this one out of hand.
Okay, Walter.
Yeah, with Art on the mailing thing, the post office doesn't return mail promptly if it can't be delivered, but they do return it. And it's been 4.5 months since the original notice was mailed to, what was it, 121
South Jackson.
South Jackson. My understanding is that was or is their business address. I'm certain, I find it hard to believe other mail wasn't going there and getting to them in some fashion. The city has mailed 3 things to that address, none of which have come back.
Correct.
And this process wasn't done without 2 or 3 stories in the newspapers, a legal notice in the newspaper, not to mention just the mailings. So I think I'm in the same position as saying, it just was not appealed in the proper timeframe.
John.
Oh, sorry.
Oh,
Go ahead.
I don't see any reason to go over this again. I agree with what the 3 of the councilmen at the other end said, and I think they're correct. That being said, I would move that we reject the appeal.
I will second that.
Now we are talking about the Von Lindren and Von Braun appeal?
Yes,
Is that what you're?
the first appellate that we listened to, or that we were.
Okay, we got a motion by John and a second by Gina to deny the appeal from the Ian Von Lindren and Margaret Von Braun. Start the roll with Walter.
Aye.
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 Okay, now we'll move on to the other appeal. Which is Ryan Pilgrim. Walter.
Mr. Mayor, may I ask the city attorney to go into a little more depth in terms of their 3 issues and his interpretation of the city's position on those 3?
Go ahead.
Well, the first issue was talking about that the decision was not supported by substantial evidence. What I provided in the packet is some case law that talks about what is substantial evidence. And I believe that they're saying that if you read it, substantial evidence is if it's based, evidence in the record that would support the decision. It may be a decision you don't agree with, but it's one that people could say, well, yeah, that could lead to that particular decision. It doesn't mean that it doesn't have to be uncontroverted either. It can be contradicted information in there as long as there's information there that would support the decision. That is substantial evidence. The second issue was arbitrary and capricious. That's basically saying that they just pulled it out of their back seat, that if there might be a record, but the decision is not based upon anything. If a governing body is acting in an arbitrary, capricious manner, basically it is doing whatever it wants, and I think would be abuse of power. There's enough information in here to show that it wasn't arbitrary and capricious. It was based upon the substantial evidence that's in the record. And then the third issue was thinking that there was some deviation from procedure, but also providing some information on what is required to establish due process and proper procedure. The main thing is that when we're dealing with local bodies, you're not going to ever have a perfect procedure or a perfect hearing, but the opportunity is to make sure that people who are concerned enough have an opportunity to come forward and have their voice heard and raise their issue. And then other people with different issues can bring them forward. And then when the body closes the public hearing, the body deliberates based upon the information that's been presented. I believe that the Board of Adjustment, as well as this body, has followed that.
Okay. Gina.
There's been some pretty important things said this evening, and I want to highlight the two of you for the things that you said. Brandy, we are indeed in this together. Deborah, we are indeed in this together. And we are not enemies, and you do indeed pay our salaries. You do, however,
Okay,
Maybe this-
hopefully you would keep it within
We got to
within the
talk
council
about
at this
this.
point.
We can't talk about what.
oh, I'm
the
sorry.
discussion.
I apologize for that. But essentially, what I am hoping to highlight is that the Board of Adjustments, every one of the individuals that sit on the Board of Adjustments are indeed volunteers. And I watched every one of the hours of their hearings and the process that they went through. And I believe that the decisions that they have made, both in the beginning and then when we remanded something or the back to them, they were supported by substantial evidence. Their decision is not, in fact, it is quite the opposite of arbitrary and capricious. And Joanne, I want to stand up for some due process and recognize the fact that I feel that this appeal, again, is worthy of being denied.
One of the things that I'd like to state here, just for the timeline on this, the public hearing was held on April 25th by the Board of Adjustment, and that CUP was approved with conditions at that time. Yeah, and correct me if I'm wrong on the dates on this, Rod, as we go along. May the 1st, the Board of Adjustment approved the relevant criteria and the standards for this.
Yes,
New
and
city
that would be the
manager's-
final decision at that
Yep.
point.
And then on May the 11th, or by May the 11th, the city received 5 appeals. And then on June 5th, the city council conducted statutory public hearings on the 5 appeals, sustained 1 and 4 were denied. Then on June 19th, the council adopted a remand decision with specific instructions to go back to the Board of Adjustment. And on July 18th, the Board of Adjustments of that hearing on the remand came back and approved that once again. And then on July 31st is when we received, and we're going to talk about the one appeal because the other one's already been denied. Point that I want to make here, ladies and gentlemen, is this is a quasi-judicial hearing as we're going through this process, and counselors nor other bodies can't just discriminately talk about this because these are very legal and very important matters, no matter how emotional it becomes for any of us. And so we have to follow the procedures. And what I heard Rod say was every single procedure was handled and followed correctly and properly from our Board of Adjustment as well as this council. Is that correct?
Correct, Your Honor.
Okay. So with that, I'll continue on. Art.
I'd just like to comment on the issue of substantial evidence. The Board of Adjustment lamented the fact that they had no data on parking in the 12 o'clock area. So to fill that data gap and to provide sufficient evidence for the Board of Adjustment to modify their decision if necessary, we asked for a renewed parking study, and the Board of Adjustment came to essentially the same conclusion, accepting the distance that parking would have to be located from the property in question. So, in fact, as opposed to lacking substantial evidence, I think they received more to assist them in their decision-making. And given that, I don't see that the capricious nature of the decision could be upheld as such.
I would make the same motion that I made before, just switch the names on it and deny the,
Okay, John, you need to make a motion. If you're going to need to make a motion, you need to make the name and appropriate. So, or we'll move on.
where is that?
Jim, you have something you want to talk about?
Well, my opinion on this is that all of these things have been really met. There was substantial evidence. The original appeal remanded it back to the Board of Adjustment
Second.
on the basis of the parking issues and the cumulative effect of the conditional use permit. And I think it was carefully considered by the entire Board of Adjustment, all the members, and they came to a decision. And it's not our place to substitute our judgment for theirs in that case. I think they did what they're supposed to do, and I think the idea that that because only one appeal was sent back and we didn't cherry pick the same items out of all the other appeals and send them back, I don't think that would have changed the remand instructions at all. And therefore, I think the Board of Adjustment has done the right thing, and I don't see any merit in this appeal.
Could you ask them what they know in the
Ma'am,
There's no public testimony.
no public hearing. This is right with our group right here. So please sit down. I hate to be short, and don't think I do not want to listen to people, but this is the procedures that we have to follow, miss. I'm sorry about that. John?
I'd make a motion that the appeal from,
Brandy, that's enough. Brandy, that's enough. This is a legal hearing, and we're not.
if you will hear them or not.
Connor, might I suggest taking a recess?
5-minute recess.